Elizabeth Glostер. Elizabeth Glostер is a legendary judge. She was the first female judge of the commercial court, commercial arbitrator in the One Essex Court. Elizabeth Glostер received an education at Rodian School and Girton College, Cambridge. She practiced as a commercial and chancery QC at One Essex Court from 1991 until 2004 before accepting an appointment as a High Court judge, becoming the first woman to be appointed as a judge of the commercial court. She was appointed to the Court of Appeal in 2013 and became Vice President of the Civil Division of that court in 2016. Since retiring from the Court of Appeal in 2018, she has returned to One Essex Court to practice as a full-time commercial arbitrator. Elizabeth had a high-profile city practice as a QC at the Commercial and Chancery Bars, specializing in corporate, insurance and reinsurance, financial markets, energy, insolvency and reconstruction cases. Elizabeth Glostер is a judge of the Abu Dhabi Global Market Court and a justice of the Court of Appeal of Bermuda. Since returning to Chambers in 2018, she has been appointed as arbitrator in a number of complex international arbitrations under PCA, LCIA, ICC, UNCITRAL, LCIA DIFC, and other institutional regimes both in London and abroad. She was treasurer of the Honourable Society of the Inner Temple for 2018 and is an honorary fellow of Girton College, Cambridge, and Harris Manchester, Oxford. She is a patron of the London branch of the CIR and a freeman of the Worshipful Company of Arbitrators.
Hello. Hello. Nice to meet you.
Very nice to meet you.
We are ready for an interview.
Yes, let's begin.
Thank you very much.
Come this way.
Dear colleagues, today we have a very interesting person at our program, and I would like to introduce you Dame Elizabeth Glostер.
Good afternoon, Alexander. It's very nice to meet you and to be interviewed by you. Please call me Liz, because Dame Elizabeth is rather a mouthful.
Okay, you could call me Sasha.
That's very kind of you. I will do that.
You are always welcome. And the first question, which we ask everybody of our program, why did you want to become a lawyer?
Well, I'm not sure I did really. My father was a businessman and I was an only child, and there was no way in the 1960s or 70s that he was going to have a woman in his business. So he said I had to be a professional. Did I want to be a doctor? No. What could I do? I could argue. So I became a lawyer. I was good at Latin. There was a lot of Latin in those days. And so I drifted into becoming a lawyer. Why did I become a barrister? I don't know. I like the idea of being self-employed, because in this country we have a split profession. And the idea of working for myself, depending on myself, seemed attractive. But hey, what did I know? I was 21 when I qualified and started my training, and I didn't really have any idea at all. I just knew I liked the law quite. If I had to work at all, law seemed quite amusing. And that's why I really rolled into it.
Could you tell me, where did you study?
I started off at a girls' boarding school, single-sex boarding school, which in the 60s was what lots of people were sent to. Then I went to Cambridge, and that was very exciting, straight from school, and that was freedom for the first time after having been at a girls' boarding school. And I studied at Cambridge for 3 years under wonderful professors and dons, as we call them at Cambridge.
Mm-hmm. Could you tell you, another one, could you tell me about your teachers? Who was your favorite teacher?
We had a marvelous, charismatic teacher called Tony Weir, who wrote a very good textbook on torts and was very, very influential because he taught us to think outside the box. He'd set a program, set a problem, and he would explain, don't just go down the route all lawyers think, come in from a different direction. And he was a great maverick, but very inspirational to generations or two of students. And he would always serve white wine at his supervisions, where there'd be 2 or 3 of us. And in a way that wouldn't happen today, he, I know, entertained me for lunch when I finished doing his paper on torts and contract he taught. So that was inspirational. I also had Professor Gareth Jones, who wrote the book on restitution, and that was fascinating. And also Professor Jolowitz, who again was a very fine lawyer. We also had a great bank of private international lawyers, public international lawyers at Cambridge. So I was privileged, very privileged.
Do you remember any funny things which happened to you or to your friends, for example, during studying at Cambridge?
Yes, I remember we were taught Roman law, which I did for 2 years, by a professor who looked, or a supervisor, and I better not give his name, but he had the most wonderful room, and he taught us about Roman law and something called perpetuities. Don't ask me what the law of perpetuities is. I think it's been abolished. And I thought his room was so special. It was about this size, but panelled with lovely books and looked straight out of a movie. And I said to him, please may I give a dinner party here? And he looked at me as though I was something the cat had brought in. And he said, no, of course not. You don't even belong to this college. So that was the sort of way in which I suppose a girl aged 18 behaved in those days. But it was wholly inappropriate of me even to have asked. And so sadly, I never got to give the dinner party in his movie set of a room.
Thank you. Could you tell me about your first steps at the law profession? What was your first place of work?
Well, I was lucky because actually the person who was in a way most useful to me was my supervisor who taught me company law, corporate law. Mm-hmm. And I was good at that because I could read accounts. And he got me a place in a very good set of corporate law chambers. And despite the fact that I turned up for my first interview wearing very, very trendy, long white PVC boots, which was not the sort of thing anybody should go to an interview in. So I got a lot of jokes about that in later life. So I stayed there for a bit. Then I went and did some ordinary commercial law, some ordinary civil law, and I finally ended up in what we called chancery chambers, which was, again, corporate law, insolvency, a bit of landlord and tenant, a rag bag. And that was very challenging. There were very few women in those days. I was the only woman in my chambers of about 30 people. So that was quite different, but it didn't seem to matter.
Mm-hmm. Was it hard to be a woman at the law profession when everybody around you were men?
It didn't seem that difficult, but it was difficult to get what we call a seat in chambers. Getting a pupillage, like a training contract, wasn't difficult in those days. But getting somebody to take you on a set of chambers where we share expenses but not profits, it was very difficult to get a seat in chambers. And I took about 3 or 4 years where my contemporaries from Cambridge or from Oxford, the men, would float in to chambers. So it was difficult to get started. But once I got started, there was very little. I didn't sense there was any prejudice, because as lawyers, what clients want is somebody who works hard, can speak to a judge properly, wins cases, or doesn't let them fight cases because the advocate has the wit to tell the client, you're going to lose this, settle on the best terms I can get you.
When you studied at Cambridge, did you think about your future career? Whom you wanted to become when you studied at Cambridge?
Well, I'm afraid, being quite young, I mean, I was 18, 19 and 20, just 21, I think, the day I finished at Cambridge. I didn't think an awful lot about my future. I was more worried about which party I was going to and who I knew and whether my social life was good. But once I realised I had to be a bit more serious, then I did think, and I was a bit more targeted about the sort of work I wanted to do. And I always wanted to do commercial work, corporate work, maybe from working for my father in the holidays as a filing clerk. Mm-hmm. I kind of knew about business, so I always wanted to go to that side. And I think it's very important that young women lawyers are encouraged to go to the commercial side, because the issues, I think, are very interesting. Traditionally, women, certainly in this country, I don't know about Russia, have been drawn to family work, criminal work. They see it more as maybe more their role, but I think there is a real need for there to be more women doing commercial work, and that was what I was attracted to.
When was your first time when you thought about being a judge?
Well, it sounds a bit hopeful, but I always knew that I wanted to be a judge. And I can remember saying to friends, well, I'm going to the bar, and then one day I'll be a judge, and High Court judge, which here is the entry level for the top senior judiciary. And I always wanted to be a judge. I was, did I structure my career? Yes, you need here to become a QC, which in those days, you got asked to become a QC, you'd apply, and you'd be asked to become one. And that was a stepping stone to becoming a judge. And I always knew I wanted to do commercial work, because it's in this country, it's not career. You go when you're about 45, 50, something along those lines. You don't go into the judiciary when you qualify. Judges are taken from the ranks of the profession, both barristers and solicitors. So I knew from early on that I wanted to be one.
Do you remember your first case as a judge?
As a judge? Goodness, no. I was a temporary judge, a deputy judge. And although it was quite prestigious when you were a practicing QC, to be a part-time judge, you do 2 weeks a year. I don't think it was a very distinguished case. Mm-hmm. You were always, as a deputy, put in a shoddy little court with poor facilities and given bad cases. But I do remember one of the best temporary jobs I had before I became a permanent judge was being on the Court of Appeal of the Guernsey and Jersey, which are two Channel Islands. Mm-hmm. And they have temporary Court of Appeal judges who are QCs. And that was great fun, because you'd be well looked after for 2 weeks, 1 week, doing very important cases, usually big trusts or big murders, in a way that when I was back in England, I wasn't doing grand cases like that.
Okay. And you had a great deal, many. Okay, let's another question. You had a great deal of different cases connected with Russia.
Yes,
Why it happened? Did you wanted to take these cases, or it just happened?
Well, I mean, it was fate in a way. My first was as a QC, before I became a judge, where I was dealing with the confiscated oil fields at the time of the Russian Revolution in 1917. Mm-hmm. Some oil fields had been confiscated, and years later there were some deposits at Bearings, and the issue in the case was whether or not in the 70s Gorbachev was going to allow the release of those deposits to pay the oil companies that had been expropriated back in 1917. And the issue in the case, and I won't bore you with why, but the issue in the case was whether it was likely that there was going to be, because of the need for Russia to get, or it was the Soviet Union at that stage, to get access to Western capital, these deposits were going to be released or not. So there was a lot of expert evidence about Gorbachev's intentions towards the West. So that was a fascinating Russian case. I then did, as a judge in the commercial court, a very interesting case about the default in 1998, when the financial markets collapsed in Russia. And I learned a lot about the Russian financial market and the derivative market that was set up by the banks and the risks of emerging markets generally. And that was fascinating, not least because the evidence relating to the escapades in the nightclubs, which the banker selling the products took his client, the claimant, too. So that was very amusing, and I learned quite a bit about Russia then. And then not even my last case, my next case as a first instance judge dealing with Russia was the Berezovский and Abramovich case, which again was a fascinating snapshot of Russia and the early days of the Russian Republic. And I found that fascinating as a history lesson, if nothing else, about those times. And then finally, one of my last cases in the Court of Appeal was Russia as a bondholder suing the Ukraine. Mm-hmm. And again, that was very, very interesting.
How do you think, is it possible to say that a Russian businessmen whom you saw a lot during the cases, they differ from businessmen from England or in other countries? How do you think?
I think it's impossible to generalize. The commercial court in London deals with all kinds of international commercial disputes involving businessmen from globalized businesses, international businesses. I think it's impossible to differentiate or to categorize. People may make jokes about Greek ship owners or Greek captains or Russian oligarchs, but I don't think you can generalize. It just depends on the person. All I can say is that in the commercial court, the judges had a vast experience of dealing with businessmen from all countries. And some were good witnesses, some were poor witnesses, some were in the middle, and one just had to look at the documents to work out where the truth lay. So I don't think you can generalize. What I think is really important is that a judicial system is fair to businessmen or parties, whatever nationality, whether they're from whichever part of the world.
Okay. What advices could you give to the young generation of lawyers, for students or just for young lawyers who want to become judges or very good advocates, barristers and so on?
Well, the first advice I would give is that it's such good fun and you have to have a real enthusiasm for legal analysis, getting the right facts, identifying the right issues. You've got to have a great love for the amusement intellectually that the law can provide. So you've got to really enjoy it. The second thing I would say, and again I'm speaking from my own experience, that presenting a case in court or in an arbitration hearing as an advocate is almost the most exciting thing. It is, apart from usually being well remunerated, it's incredibly hard work with a client, and often a worried or concerned client. It's incredibly responsible, and winning the unwinnable case is terrific and a great thrill. Sadly, one sometimes loses the unlosable case, having told one's client that he's bound to win, and that is very, very bad. So with the thrill comes the huge disappointment and concern on some occasions. So my advice would be, become a lawyer that presents arguments in court. That would, part share your career as a professor of law. I would say no, don't stick in academia. Go into the real world and be an advocate. And I'm very interested in my new role as an arbitrator to see how much advocacy there is in arbitration. It's still very important, oral advocacy. I would also give this advice, and maybe this is a bit sort of Anglo-Saxon type of advice. I think it's very important that if you want to become a judge, and before you become a judge, you have real life experience of pleading a case, being in court, being in a tribunal, so you understand the dynamics and the drivers for litigation or arbitration. In my experience, and again I can only speak from the Anglo-Saxon common law experience, it's better to become a judge once you've had a career as a lawyer with the responsibilities and the understanding of how difficult actually presentation is, and how the right outcome isn't necessarily the just outcome in accordance with the law. And that is a lesson one needs to learn about the pressures of litigation or arbitration. At the end of the day, however, I think I certainly enjoyed being a judge, and now I'm enjoying being an arbitrator. Perhaps even better, because the intellectual satisfaction of getting the right answer after a time becomes more stimulating, more satisfying than being paid to present an argument which you know may not be the correct argument. So although it's very intellectually challenging and amusing to present a case in court, at the end of the day, the most certainly intellectual enjoyment I've had is writing a judgment, writing an award, and knowing that whatever the appellate court upstairs may say, in your own mind you've reached the right answer. And that's exciting.
Okay, how do you think, what qualities should obtain the successful barrister or advocate?
I think you've got to be very objective. You can't be persuaded by your own arguments. You've also got to be very phlegmatic. You can't let things worry you or make you cross. It's like being a taxi driver in London. You can't get upset by appalling other drivers. You've got to be calm, and you've got to be able to take a decision on your feet and then live with it and not regret it. So I think objectivity, resolution, and courage, because sometimes the judges can be unpleasant, they can be apparently biased, or they can just be difficult, and you have to stand up to them and maintain your position, maintain your case where appropriate. On the other hand, if you suddenly are forced with the reality that your case on one aspect is bad, you should regroup, reassess, and not run with a bad point. And a lot of advocates bang on bad points when they should have the realization that actually if they approach the problem from a different angle, it might be more successful.
The first question. Why do you think the jurisdiction of England is so attractive for Russian business?
Oh dear. Because I think we're impartial. The judges here are very impartial. I also think there's access to a wide realm of expertise. We have huge depth of experience and expertise in our lawyers, our advocates, our solicitors. And also the English common law, if it applies to the dispute, is very flexible and very user-friendly. On the whole, it's certain, so the principles are certain, outcomes are certain. So I think these are the factors that contribute to the English jurisdiction being popular with Russian businessmen, international businessmen generally. And hey, London's a nice place to litigate in.
Do you think the Russian legal system needs a precedent?
Precedent in the sense of binding authorities?
Yes.
Yes, I think the doctrine of precedent is useful. I think and again I would say this because I'm a common lawyer, I think it produces certainty and to a certain extent flexibility as well. If you have a doctrine of precedent, you're not just looking at a code in isolation, you're looking at the applications of legal principles over the years, and you can see how doctrines develop. So I wouldn't be presumptuous enough to say that Russian law needs one, but I think it's a useful doctrine to have.
What the most unusual evidence was referred to by the parties during the trial?
Are you talking about the Berezovский trial or some other trial? I don't think I should answer that.
What literature could you advise Russian students to study the litigation in the UK?
I think if Russians are studying litigation, they should look at oral presentation of argument, because I think that we have a long tradition of advocacy and judges being willing to receive oral presentation of argument. And that's, to me, I may be wrong, seems to me to be a differentiating factor between English advocates and some continental advocates. Mm-hmm. And certainly I am surprised that in international commercial arbitration, so much emphasis still is placed on oral argument. So I think the tradition of oral presentation at all levels would be a useful one for a Russian student to study.
Okay, and the next question. Which categories of cases do you think are the most complicated?
The most?
Complicated.
Oh, complicated. I think probably intellectual property cases are incredibly complicated. I haven't done very many of them, but unless you have a scientific background, it's difficult to feel comfortable with the concepts and sometimes the jargon, the language they use. Once you get into the jargon and you understand the concepts, then it's much easier to understand them. But on the whole, most disputes at the end of the day involve understanding the language, understanding the world you're in, whether commercial or insurance or whatever. So I think that cases that require some sort of scientific understanding are perhaps the most complicated. But hey, at the end of the day, for a judge, everything is easy, of course.
Dear Liz, thank you very much for the interview. I have some presents for you. Here are the books on Russian law.
Wow, dispute resolution in Russia, the essentials. Russian company law, the essentials.
Absolutely right. And this cup, our Moscow lawyers cup. And here is our slogan, don't judge the lawyers, they're people too.
Oh, surely not, surely not. Thank you very much indeed. It's been a real privilege being interviewed by you, and I hope it doesn't come out too badly.
It was excellent, and supposed to see you at Moscow or in St. Petersburg.
Lovely. Thank you
you.
so much.